Well, today's topic is on historical background on International Bill of Rights. The first introduction. As a matter of fact, the concept of human right was primarily in rudimentary form in ancient time. Even in the Middle Age period, it was found to be in a formative stage. However, it started developing in the 20th century. Especially with the formation or establishment of the World Organization. It is worth mentioning that the concept of human right has been crystallized at the global level in a gradual process. And it is also the fact that human right was not an overnight creation of someone or somebody, but it was obviously the byproduct of main struggles against the tyrannical rules and system. The human history also reveals the true picture of such development in the human right front. The League of Nations and the abolition of slavery. We are all aware of the fact that the League of Nations established under the League Covenant is often termed as a child of war because of its formation after the unprecedented devastating effect of the First World War. Besides the outbreak of such World War, there were certain other influential factors also in adopting and establishing the League Covenant and the League of Nations by the world community. For instance, the formation of the concept of human right particularly may relate with or may have a certain background impact from the concert of Europe, the adoption of the Hague Conferences of 1899 and 1907, and the movement of universal postal unions, where some of the historical significant issues that had greatly molded the international public opinion for installation of the World Organization. Though the need of establishing such a global body was felt necessary even prior to the outbreak of First World War, it took its real shape only when the Treaty of Versailles was adopted in 1919. It is evident that the world community had the desire to set up such an international body which could prevent such unprecedented man-made war and conflict, so as to save the people of the world from the massive violation of individuals' life and liberty. The League of Nations, as a part of Treaty of Versailles, had its certain purposes and objectives as set forth in the Covenant of League of Nations, such as to maintain international peace and security, to settle international dispute, and to promote international understanding and cooperation among the national states, etc. Another important unique feature of the League of Nations was that of its positive measures to eliminate slavery, forced labor, and immoral trafficking of women and children. Though the term human right as such was neither defined nor mentioned in any part of the League Covenant, the aim of the League of Nations was very clear that the global organizations began to evolve its initiative to promote and protect the basic fundamental human rights of individuals. These undoubtedly express the international concern over certain issues of the basic rights and freedom of individuals and persons. Even during the 19th century, the measures for evolution of slave trade and slavery practices were adopted at different parts of the world. For instance, Great Britain started abolishing such inhuman practices throughout the dependent colonies from 1807. France and Great Britain entered into an agreement under the banner of Treaty of Paris, 1814, especially for abolition of the practice of slavery. Eventually, the Anti-Slavery Act of 1890 was also signed and ratified by as many as nearly 24 of independent states at that point of time. So therefore, the global initiative in respect with the abolition of such inhuman practices virtually led to recognition of human rights such as right to life, equality, and dignity of all human beings. Further, the adoption of Slavery Convention of 1926, which was amended by the Protocol to Slavery Conventions of 1953, also reaffirmed the prohibition of slavery or slave trade and slavery at the global level. The protection of rights of disadvantaged people. The other aspect of evolution of global concern on human rights was in regard to the protection of rights of labor and workers. The International Labour Organization, in short ILO, which was set up in 1919, worked extensively for protection of those people belonging to disadvantaged section of human society. The International Labour Organization, ILO, also carried out its activity in collaboration with the League of Nations in this regard. Such global forum also opened a large scope for establishing an effective system in order to develop and coordinate with those international machineries working on the principles based on socio-economic justice. However, the forum did not precisely define the right and freedom of those individuals. Article 23 of the Covenant of League of Nations also dealt with the condition of labor, but this particular function of the League was later on taken over by the International Labour Organization under certain terms and conditions laid down in the international agreement between the ILO and the League of Nations. The League of Nations also had the mandate under the League Covenant to protect the right and freedom of minority people. Though the Covenant of League neither defined the right and freedoms of those people nor regulated the protection of them, the League eventually derived its authority from the various international multilateral treaties which were adopted after the First World War. It is clear that the League of Nations undertook the role of global guarantor for the nation states which had obligated their responsibility under those international agreements. Some of the significant measures undertaken in this regard by the League of Nations were: number one, to provide the right to petitions in favor of minority people in case of violation of their rights and freedom. And second, to create a minority committee by the League Council as a competent international mechanism to deal with issues of minority people. Such institutional setup at the global level and its call for protection of rights and freedom of minority people under the Covenant of League of Nations virtually indicated that the issue of human rights for minority people was also taken as an international concern, but not as a mere state or local issue. Subsequently, this development also created an unprecedented limitations on the part of the national governments under the global rules and regulations. Mandate system under the League of Nations. The other important aspect of League of Nations was the mandate system established under the League Covenant. This system was basically empowered to monitor and supervise over the manner in which the native population of those mandated territories were treated and governed by the metropolitan countries. The mandate system also proclaimed the very basic principles, I quote, the well-being and development of the people in the mandated territories form a sacred trust of civilization, unquote. So therefore, the mandated power was required to administer these dependent territories under certain universally accepted terms and conditions, so as to guarantee freedom of conscience, religions, prohibition of abuses, denial of basic human rights of those individuals. This is also the fact that both the International Labour Organization and the League of Nations gave serious emphasis on promotion and protection of socio-economic as well as civil rights of individuals with different perspectives. However, those initiatives and efforts made by the League of Nations were brought to the end due to the dissolution of League of Nations. Interestingly, the adoption of the Charter of United Nations in 1945 allowed to continue those measures initiated by the League of Nations in certain areas under certain circumstances. For instance, the United Nations trusteeship system established under the Charter of UN has been entrusted with similar functions of the past mandated system of the League. This reveals that the United Nations has also followed the same suit. Such establishment of international institutions with global measures have also been found and developed consistently in a systematic way even after the dissolution of League of Nations. In a similar way, the International Labour Organization, as an autonomous international body, has certain global objectives based on the principles of socio-economic justice for all the people and for all the nations. The function of International Labour Organization was primarily associated with the League of Nations. However, after the dissolution of the League, the International Labour Organization has become an affiliated international entity to the United Nations from 1946 onward. Through an agreement between the International Labour Organization and the United Nations, particularly under Article 63 of the UN Charters. Hence, it is undoubtedly clear that the process of global endeavor for protection of human rights began with the formation of world organizations. And the same process has also been continued by the United Nations and its agencies. Next, we may have a discussion on human rights and United Nations. Human history shows that the idea of making a universally accepted standards and norm of human rights has begun even before the outbreak of Second World War. We witnessed two devastating world wars that had ultimately led to the formation of two international organizations. That is, number one, the League of Nations was established after the First World War in 1919 with the main objective to maintain peace and security in the world. But it had miserably failed to realize its objective because of certain profound reasons. Number two, the United Nations was also set up in 1945 after the Second World War with overwhelming consensus among the international community. It was failed and realized those responsible factors for failure of the League of Nations by the world community. And the maker of this charter also realized that the United Nations could not fulfill its cherished goal at all without protecting human rights and freedom of individuals of the world. The term human rights are simply mentioned without defining or enumerating them in the Charter. Hence, there is nothing wrong to say that the contemporary human rights jurisprudence was therefore gained its importance largely due to the active global involvement and concern over the gross violation of human rights, particularly during the First and Second World War. The actual idea of creating a universally accepted Bill of Rights initially took its shape at the Dumbarton Oak Preparatory Conference held in Washington in 1944. The same has also been reflected in the Charter of United Nations. And as many as 7 references of human rights have been found running like a golden thread through the world constitutions. The people of United Nations, through the preamble of the Charters, profoundly express their firm determinations to reaffirm faith in fundamental human rights, in dignity and worth of human persons, in equal right of men and women. The World Constitution explicitly recognizes the promotion and respect of human rights as one of the major objectives of the United Nations. This has created an indispensable obligation for both the United Nations and its members to initiate and improve the global measures on human rights front. Therefore, the Charter itself is the foundation as well as the sole international document which provides a scope for further development in the field of human rights. As a result, the United Nations, especially the United Nations General Assembly, the International Court of Justice, the UN Human Rights Council, Economic and Social Council, and other UN specialized human rights bodies have been entrusted with such global responsibility in this regard. We may also discuss on the issues pertaining to global measures on human rights front. The Charter of the United Nations was primarily adopted as an international multilateral treaty. But during the passage of time, it has turned to be a unique world document. The provisions of the Charter bear the binding force of international law, and all the member states of the United Nations have also pledged their binding obligations under the Charters, including the obligation to promote and respect for human rights, to promote observance of human rights, and to cooperate with the United Nations and other nations so as to attain the main objective set forth in the Charters. However, one of the practical issues for realizing such objective by the United Nations is the question of state domestic jurisdictions, as provided in the Article 2, Clause number 7 of the Charters, which states that, I quote, "Nothing contained in the present Charter shall authorize the United Nations to intervene in the matters which are essentially within the domestic jurisdictions of any states, or shall require the members to submit such matter to the settlement under the present Charters. But this principle shall not prejudice the application of enforcement measures under the Chapter 7, unquote." So it is true that on one hand, the issue of human rights of individuals obviously falls on state jurisdictions, as individuals belong only to the state as its subject. The another reasons may be the status of state sovereignty, which has been remained intact, even though strong international organizations were formed by the member states. On the other hand, the issue of human rights and fundamental freedom of individuals has become the solemn subject matter of international law and system due to the emergence of global regimes. Even the term essentially within the domestic jurisdictions, as mentioned in the Article 2, Clause number 7 of the Charter, is also not defined in any provisions of the Charters. However, very interestingly, both the terms domestic issues and global issue pertaining to human rights are always found to be closely interwoven. It may also be noted that the exception clause in respect of the application of enforcement measures under Chapter 7 of the Charters indicates the mandatory obligations of the United Nations to discharge its duty in case of gross violation of human rights which may take place elsewhere in the world. Hence, the human rights issue, either it may occur in a local area or in a state, has virtually crossed the territorial boundaries of the state, and it has ultimately become a global issue rather than a mere local issue. And that is why the obstacle for the United Nations, as set forth in the Article 2, Clause number 7 of the Charter, has been found eroded. Even there may be a direct or indirect threat to the international peace and security, the United Nations ought to take off its positive steps and measures by considering the involvement of such issue with human rights in one way or other. So the traditional concept of individual as the only object of international law and organization is eventually found to be diluted to a great extent. And during the passage of time, individual has also become the subject of such international law and bodies, rather than a mere object of them. So therefore, the practical embodiment of the United Nations has been gradually withered away, especially in the matter of human rights. And this may be understood when we analyze the contribution of the United Nations and its agency, particularly in the field of human rights. Last but not the least, the conclusions, we may look at how the UN has attempted to evolve International Bill of Rights. In the absence of clear terms of human rights in the Charter of United Nations, the task for promoting and respecting of human rights has been entrusted to the United Nations General Assembly, the Economic Social Council, the UN Human Rights Council, the UN Human Rights Commission, so-called Commission on Human Rights, and their subsidiary bodies. So as a result, human rights became a part of global programs as well as a major agenda sponsored by the United Nations organ and its agencies since the very inception of United Nations. The international organizations also mark a new beginning in the history of human rights by breaking through the traditional notion of state sovereignty as being the only sole authority to deal with the right and freedom of subject. The global human rights programs so far undertaken within the legitimate framework of the Charter has also clearly signified its historic achievement in the process of evolving a unique international benchmark on Bill of Rights. Thank you.